Chapter 10 of the Remedy by Action, Assignment of Breaches, and Pleadings. Debt is the proper form of action upon bonds, whether single or with condition. Covenant will also lie, though that remedy is seldom used in practice. In general, debt cannot be maintained for the recovery of money payable by installments, unless the whole amount be due, but in the case of a bond, with condition to pay money by installments, the bond is forfeited by the non-payment of one installment, and the penalty becomes a debt in law, for which an action of debt may be maintained. And it may be observed that the execution of a bond creates a debt or duty, which adheres to the obligor wherever contracted, and therefore a bond executed abroad may be put in suit in this country, but in that case the declaration should state the true place at which it was made. Where the obligation is to pay a sum of money at several days, the obligee cannot maintain an action of debt until the last day be passed. A bond, being a mere chosen action, is not assignable so as to give the assignee a right to sue in his own name, and therefore the action must in general be brought in the name of the obligee or his executor. There are, however, exceptions to this rule in the case of bail bonds, replevin bonds, and India bonds, where a power to sue is given to the assignee by statute, and where a foreign prince acknowledges himself and his successors bound to every person who shall for the time being be the holder of the bond. This latter instrument is analogous to a bank note payable to bearer, or to a bill of exchange endorsed in blank, and conferring a title on any person honestly acquiring it. The obligor may be holden to bail in all cases, except on replevin or bail bonds. But where the bond is conditioned for the payment of money, he should only be arrested for the sum really due by the condition. So if the bond be for the performance of covenants, or to indemnify, or the like, the bail required should be to the amount of the damage sustained and not of the penalty. Though upon a bond, with a penalty conditioned for the payment of a less sum by installments and interest, the obligee may arrest for the aggregate amount of all the installments and interest, notwithstanding a part only are due. And when the penalty is in the nature of liquidated damages, as upon a bond conditioned for the performance of a promise to marry, the obligor may be held to bail for the amount of the penalty. The affidavit must show that the bond is due and payable, and therefore where it stated that the obligor was indebted to the obligee in £6,000 upon a bond in the penal sum of £25,000, without showing the condition of the bond, the court discharged the defendant on filing common bail. But an affidavit for principal and interest due on a bond is sufficient, without stating the bond to be conditioned for the payment of money. In declaring on a bond it is not necessary to show a consideration, but the declaration proceeds at once, without any inducement, to state that the defendant on a certain day by his writing obligatory, sealed with his seal, and shown to the court, acknowledged himself held and firmly bound to the plaintiff in a sum of money to be paid to the plaintiff, and it then alleges a breach in the non-payment of that sum. There is some doubt by what name the obligor should be sued, or the obligee sue, where they are described by one name in the bond, and have executed by another. It has been decided that a declaration against an obligor by his right name, stating that he executed the bond by a wrong name, is bad. But it seems the proper course is to declare by or against a party by the name in the bond, unless he is there called by different names, in which case he should sue or be sued by the name by which he executed. With respect to the statement of the day on which the bond was made, it should be observed that every deed is supposed to be delivered and made on the day on which it bears date. But when the bond has been delivered after the time of its date, and that fact is material to the obligee's right of action, as in the case of a release having been given by him to the obligor after the date, but before the delivery of the bond, the declaration should state the bond as bearing date on the day therein mentioned, but delivered afterwards, for if the obligee declare on the bond as made on a particular day, he cannot afterwards reply that it was delivered on another and a different day, since, as a bond takes effect from the day of its delivery and not of its date, the replication would be inconsistent with, and a departure from, the declaration. The declaration should show that the bond was sealed by the defendant, but if the words "sealed with his seal" be omitted, the defect will be cured by verdict or pleading over, for when it is stated that the defendant by his writing obligatory acknowledged him, self-bound, all necessary circumstances will be intended. In the case of bonds executed abroad, which do not by the custom of the country require a seal, the declaration should not describe them as sealed instruments, but as writings obligatory subscribed by the obliger, and duly made according to the custom of the country. The bond being the foundation of the action, a proffered must be made, in order that the court may judge whether it be properly executed. But if it have been lost by time or accident, or is in the possession of the obliger, and cannot, therefore, be produced to the court, any of those facts may be alleged by way of excuse. So it seems if a stranger declare upon the bond, as in the case of an action by the assignees of a bankrupt, a proffered is unnecessary. In all cases the excuse being traversable, must be stated according to the fact, though if the allegation is true at the time of declaring, it is sufficient, and the bond being afterwards found will not vitiate it. But if proffered be made when some excuse should have been alleged, the defendant will be entitled to oyer, and if the bond be not produced when claimed, or at the trial, the plaintiff will be non-suited. In general the bond should be set out in terms, but if it be stated according to its legal effect it will be sufficient. Where the declaration stated that the defendant was bound to the plaintiff for payment of money to him, his attorney, or assigns, and it appeared upon oyer of the bond, that the payment was to be made to the attorney, or his assigns, without mentioning the plaintiff himself, the bond was held to be properly set out. So in a declaration by the treasurer of a friendly society on a bond given to a, then being treasurer, and the bond produced in evidence was to a, without stating him to be treasurer of the society, this was considered no variance. And when a person is bound to perform any act to the obligee, and for performance of which he binds himself in a sum of money without saying to whom, the declaration ought to state that he bound himself to the plaintiff by the words of the bond. A declaration on a joint bond is supported by proof of a joint and several bond. But wherein a declaration on a joint and several bond, the condition was stated to be for payment of money by the defendant C and D, and it appeared on the production of the bond to be conditioned for payment by the defendant C and E, whose name had been substituted for that of D, after the execution of the bond with the assent of the obligee, but without the knowledge of the defendant, this was held to be a fatal variance. So where to debt on bond the defendant prayed oyer of the condition, which was for payment of 100 litres, by instalments, till the said sum of £100 be paid, and it appeared the word 100 had been omitted in the second place where it occurred in the condition, and was afterwards inserted without the defendant's knowledge, this was considered a fatal variance in the description of the condition. But now the 9 Go. 4, c. 15, has enabled any court of record holding plea in civil actions, and any judge sitting at Cyprus, if they think fit, to cause the record, when a variance appears between any matter in writing or in print produced in evidence, and the recital and setting forth thereof upon the record, to be forthwith amended in such particular by some officer of the court on payment of such costs, if any, to the other party, as such judge or court shall think reasonable, and thereupon the trial shall proceed as if no such variance had appeared, and in case such trial shall be had at Cyprus, the order for the amendment shall be endorsed on the postua, and returned together with the record, and thereupon the papers, rolls, and other records of the court from which such record issued shall be amended accordingly. Where the penalty of a bond stood as a security for the payment of a less sum, or for the performance of several distinct acts, the obligee was entitled, upon a breach of the condition, to recover at law the full amount of the penalty, without any regard to the damage he had actually sustained. In such cases the obliger's only remedy was by application to a court of equity for relief upon payment of the sum really due, for the purpose of rendering this circuitous redress unnecessary. The 8th and 9th will. 3, c. 11, sect. 8, enacted, that in all actions upon any bond or bonds, or on any penal sum for non-performance of any covenants or agreements in any indenture, deed, or writing contained, the plaintiff or plaintiffs may assign as many breaches as he or they shall think fit, and the jury, upon trial of such action or actions, shall and may assess not only such damages and costs of suit as have heretofore been usually done in such cases, but also damages for such of the said breaches so to be assigned as the plaintiff upon the trial of the issues shall prove to have been broken, and that the like judgment shall be entered on such verdict as heretofore hath been usually done in such like actions, and if judgment shall be given for the plaintiff on a demurrer, or by confession of nihil dicit, the plaintiff upon the roll may suggest as many breaches of the covenants and agreements as he shall think fit, upon which shall issue a writ to the sheriff of the county where the action shall be brought, to summon a jury to appear before the justices or justice of assize or nisiprius of that county, to inquire of the truth of every one of those breaches, and to assess the damages that the plaintiff shall have sustained thereby, and in case the defendant or defendants, after such judgment entered and before any execution executed, shall pay unto the court where the action shall be brought, to the use of the plaintiff or plaintiffs, or his or their executors or administrators, such damages so to be assessed by reason of all or any of the breaches of such covenants, together with the costs of suit. A stay of execution of the said judgment shall be entered upon record, or, if by reason of any execution executed the plaintiff or plaintiffs, or his or their executors or administrators, shall be fully paid or satisfied all such damages to be assessed, together with his or their costs of suit, and all reasonable charges and expenses for executing the said execution, the body, lands, or goods of the defendant, shall be thereupon forthwith discharged from the said execution, which shall likewise be entered upon record, but, notwithstanding, in each case such judgment shall remain, continue, and be as a further security to answer to the plaintiff or plaintiffs, and his or their executors or administrators, such damages as shall or may be sustained for further breach of any covenant or covenants, in the same indenture, deed, or writing contained. Though the word may is used in the above statute, it has been decided that it is compulsory on the plaintiff to assign breaches in all cases which fall within it. Questions have, however, frequently arisen as to the description of bonds within the terms of the statute, the chief object of the legislature having been to enable a jury to ascertain the damage sustained by a breach of the condition, without compelling the obliger to resort to a court of equity. It would seem that it may in general be determined in what cases it is necessary to assign breaches by considering whether the precise sum due can be ascertained without the intervention of a jury or a court of equity. Thus bonds for the payment of annuities or of money by installments, for the performance of an award, or for the performance of covenants and agreements, are within the provisions of the statute. So where a bond appeared conditioned for the payment of a sum certain, but by an indenture of even date it was agreed that the plaintiffs should be at liberty to enter up judgment when they thought fit, it was held to be substantially a bond conditioned for the performance of an agreement, and that breaches ought to be assigned. Also where the obligee of an indemnity bond is sued for damages in respect of the matter of the indemnity, which are recovered against him, and he afterwards proceeds against the obliger on his indemnity, the obligee should assign as a breach not only the damages and costs recovered against him, but also his own costs sustained in defending the suit, although he may in fact as yet have paid no part of such costs. But bonds for the payment of a sum certain at a day certain, and post-obit bonds, are not within the statute, neither are bail bonds nor eplevin bonds. For in the two latter cases the courts of law can exercise an equitable jurisdiction, nor bonds given by the petitioning creditor of a bankrupt, and if an annuity be secured by a warrant of attorney to confess judgment on a mutuatus breaches need not be assigned. Also bonds which fall within the provisions of the Foran, c. 16, s. 13, which empowers the court, pending an action on the bond, to discharge the defendant upon payment of the principal and interest due and costs. So where a bond is conditioned for the payment of a sum of money on a day certain, with interest in the meantime, pursuant to the provisions and stipulations contained in an indenture, upon the non-performance of which both principal and interest became due, it is not necessary to assign breaches according to the statute, nor is it necessary in any case for the Crown to assign breaches. Under the above statute the plaintiff may either assign or suggest breaches on the roll, but he cannot do both. It was formerly considered that breaches should be assigned in the declaration, because if the defendant pleaded any plea, upon which the plaintiff might at common law have taken issue, without assigning a breach, it would be incorrect to assign them in the replication. It is now, however, established that the plaintiffs not only may, but that it is advisable, unless judgment by default be expected, to reserve them for the replication, since the defendant in rejoining can only present one answer to each breach, whereas in pleading to the declaration he may with leave of the court answer each breach by any number of pleas. If the defendant suffer judgment by default, or the plaintiff get judgment upon demurrer, or where the plea cannot lead to an issue on the breaches, as upon non est factum, or that the bond was obtained by fraud and covin, the plaintiff may suggest breaches on the roll. But if the plea be such that breaches may be assigned upon it, as a plea of performance, and the plaintiff take issue on the plea and enter a suggestion of breaches on the record, no damages can be assessed on them, and the court will award a repleader. Before the above statute the plaintiff could assign only one breach of the condition, or the declaration would have been bad for duplicity. It is not, however, necessary in a declaration, assigning more than one breach, to refer to its being according to the statute, nor is it necessary in a replication, assigning only one breach, but if the replication assign more than one it is otherwise. The breach should be assigned with certainty and particularity, though the superaddition of immaterial allegations will not vitiate it, if it be in other respects good. To a plea of non damnificatus, the replication should show how the plaintiff was damnified. To a plea of no award the replication must set out the whole award and also assign a breach. And to a plea of performance to a bond conditioned to render an account of monies received, it is necessary to show in the replication that monies were received to be accounted for. Though where a fact lies more within the knowledge of the defendant than the plaintiff, a general allegation is sufficient. Thus where the condition was to account for and pay over to the plaintiff, as treasurer of a charity, such voluntary contributions as should be collected for the use of the charity. And to a plea of performance the plaintiffs replied that divers sums of money had been received, amounting to the sum of £100, from divers persons for divers voluntary contributions, for the use of the said charity, which had not been accounted for or paid over. The replication on demurrer was considered sufficiently certain. Where the condition was not to assault, molest, or injure the plaintiff, a replication alleging that the defendant assaulted, and c. by the beating and ill-treating the plaintiff, was considered a sufficient assignment of the breach of the condition, although not in formal terms, according to the statute. And where to debt on bond, conditioned for payment of a sum of money on a day specified, according to the tenor and proviso contained in a certain indenture, and for the performance of the covenants therein, the defendant pleaded that there were no negative or disjunctive covenants in the indenture, and that he paid the money on the day specified, and performed all the covenants and provisos in the indenture, and the defendant took issue generally on the non-payment of the money, and concluded to the contrary. Such replication was held proper, as the only point in issue was the payment of money. So where to a declaration on bond, conditioned amongst other things for the payment of £3,000, it is pleaded that all sums of money which became due on the bond were paid, the replication may deny the words of the plea, without assigning any particular breach. Where the defendant would dispute the execution of the bond, or if the proffered cannot be proved as stated, or the bond has not been duly stamped, or there is a material variance in the statement of the bond, non est factum is the proper plea. In reference to this plea it was formerly material to observe the distinction between a bond absolutely void or merely voidable. In the former case the plea of non est factum was sufficient, but in the latter instance it was necessary to plead the special matter. Now, however, the plea of non est factum only operates as a denial of the execution of the deed in point of fact, and all other defenses must be specially pleaded, including matters which make the bond absolutely void, as well as those which render it voidable. In order to take advantage of a defect not apparent on the face of the declaration the defendant must crave oyer of the bond and condition, or either of them. So if he would plead payment or performance of the condition not set out in the declaration, he should pray oyer of it. But if oyer of the bond be craved the defendant is not entitled to oyer of the condition, without that be craved also, for the obligation and condition are separate and distinct instruments. After craving oyer the whole condition should be set forth, with all the recitals, for if the defendant omit any part, or do not state it correctly, the plaintiff may pray to have the bond or condition or either of them enrolled, and then demur, or sign judgment as for want of a plea. In practice it is not usual to set forth the bond without the terms of it are material to the defense, and unless some use is intended to be made of it, it is sufficient to pray oyer of the condition only. The defendant by craving oyer may in some cases aid a defect in the declaration, as where the plaintiff declared upon a certain writing, and the defendant, by praying oyer of the condition of the said writing obligatory, admitted it to be a bond. The requisites of a good bond and condition, and the performance thereof, and also the effect of alteration having been fully considered, the matters of defense relating thereto may be easily collected. And it may be here observed that the obliger is not restrained from pleading any matter which shows the bond to be void, though such plea be inconsistent with the language of the bond. The pleas however of performance, accord and satisfaction, duress, set off, and the limitation of action, require some particular notice. Where the bond is conditioned for the performance of covenants which are in the affirmative, a plea of general performance is proper, and the plaintiff must reply, showing a particular breach. But if there be any specific or particular thing to be performed, or the covenants are in the negative or disjunctive, performance of each must be particularly stated. To a single bill or bond accord and satisfaction can by deed only be pleaded, for an obligation under seal cannot be discharged but by an instrument of as high a nature as the obligation itself. So also to bond with condition, satisfaction after breach of the condition should be by deed, for by non-performance of the condition the bond becomes single and the penalty is the debt in law. As far as can be collected from the old authorities, an opinion seems to have prevailed that accord and satisfaction before a breach of the condition was a good plea if pleaded to the condition and not to the obligation. This point however does not appear to have been anywhere expressly decided. Where satisfaction is by deed its value is immaterial, but assuming that it may be pleaded to the condition without deed, it must be of something valuable in contemplation of law, and therefore the release of an equity of redemption, or one bond in lieu of another, is no satisfaction. So payment of a part before the time, and a promise to pay the residue at a future day, cannot be pleaded, yet it seems that payment of a less sum before the day, and acceptance thereof in full satisfaction, is a good plea. Duress of imprisonment is a good plea to debt on bond, but the duress must be of the person of the defendant or his wife, and therefore a surety in a joint and several bond cannot plead the duress of his principal to an action against himself. In general it must appear that the imprisonment was unlawful, but if illegal force be used, or the party be made to endure unnecessary privation or hardship, it will constitute duress notwithstanding the imprisonment was by virtue of legal process. The 2g. 2c. 22, enabled a defendant, in the case of mutual debts, to set off one debt against the other. It was doubtful, however, upon the construction of this statute, whether a debt on simple contract could be set off against a bond, being a specialty, and also whether the penalty of the bond was to be considered the debt. To remove these difficulties the 8g. 2c. 24, s. 5, which made the above act perpetual, enacts and declares that mutual debts may be set off against each other notwithstanding such debts were deemed in law to be of a different nature, unless in cases where either of the said debts should accrue by reason of a penalty contained in any bond or specialty, and in all cases where either the debt for which the action is brought or the debt intended to be set against the same hath accrued by reason of any such penalty, the debt intended to be set off shall be pleaded in bar, in which plea shall be shown how much is due on either side, and in case the plaintiff shall recover in any such action a judgment shall be entered for no more than shall appear to be due to the plaintiff after one debt being set against the other as aforesaid. It would be deviating from the plan of the present treatise to enter fully into the law of set off, but the general rules on that subject will be illustrated so far as they are applicable to bonds. The debts sued for and intended to be set off must be due in the same right, and therefore a debt due to the obliger in right of his wife cannot be set off in an action against him on his own bond. And where an officer of the palace court sued on a bail bond conditioned for the appearance of A, B, to answer C, D, in a plea of trespass on the case, it was held that the defendant could not plead by way of set off a greater sum due to him from the plaintiff by a simple contract, for the plaintiff sued in the nature of a trustee and not in his own right, though if the bond had been given to the sheriff and assigned according to the statute, it would have been otherwise. But it is a good plea in an action by a trustee to show that money is owing from the cestui que used to the defendant. A joint debt cannot be set off against a separate demand, or a separate demand against a joint one. But a debt on a joint and several bond may be set off to an action brought by one of the obligors, and if such bond be executed by one of the obligors only, it may be set off against a claim by him. The debt claimed and the sum to be set off must be an actual money demand, and therefore there cannot be a set off when the action is brought for uncertain damages, as to a bond for the performance of covenants. Nor can an unliquidated demand, or uncertain damages, though secured by a penalty, be made the subject of a set-off. But where a bond is conditioned for the due performance of certain work in a limited time, or payment of a stipulated sum weekly, such weekly payments are in the nature of liquidated damages, and not by way of penalty, and may be set off in an action brought by the obligor against the obligee. Also a bond for the payment of an annuity is within the statute of set-off. The sum intended to be set off must be a legal and not a mere equitable claim, and therefore a defendant cannot plead by way of set-off a bond debt of the plaintiff assigned to the defendant by another, to whom, and for whose use, it was originally given. It must be a subsisting legal demand, and therefore a debt barred by the statute of limitations or satisfied by the discharge of the debtor out of execution, cannot be set off. The sum to be set off must be actually due and payable at the commencement of the action, and therefore money secured by bond, not due at the time of the writ issued, cannot be set off. The Bankrupt Act, 6 4 c. 16, s. 50, has extended the law of set-off to mutual credit as well as mutual debt. The plaintiff in his replication may traverse either the amount alleged to be due from him, or the defendant's set-off. If he should reply that more was due on the bond than the sum named in the plea, and fail in proving that allegation, he would be non-suited. The plaintiff may also reply non est factum, or admitting the bond, show any matter in discharge or avoidance of it. Formerly there was no statutory enactment to limit the time for bringing an action on bond, but after a period of 20 years, without demand made, it was presumed to be satisfied. But the 3 and 4 W. 4 C. 42, s. 3, requires all actions of debt on bond to be commenced and sued within 10 years after the sessions in which that act passed, on within 20 years after the cause of action or suit. The 4th section enacts that if any person entitled to such action or suit shall be, at the time the cause of action accrued, within the age of 21 years, feme covert, non compos mentis, or beyond seas, then such person shall be at liberty to bring the same action, so as they commence the same within such times after their being of full age, discovert, of sound memory, or returned from beyond the seas, as other persons having no such impediment should according to the provisions of that act have done, and that if any person, against whom there shall be any such cause of action, shall be at the time such cause of action accrued beyond the seas, then the person entitled to any such cause of action shall be at liberty to bring the same against such person, within such times as are before limited, after the return of such person from the seas. Provided that if any acknowledgment shall have been made, either by writing signed by the party liable by virtue of such specialty or his agent, or by part payment or part satisfaction on account of any principal or interest being then due thereon, it shall be lawful for the person entitled to such action to bring his action for the money remaining unpaid and so acknowledged to be due within 20 years after such acknowledgment, by writing, or part payment, or part satisfaction as aforesaid, or in case the person entitled to such action shall at the time of such acknowledgment be under such disability as aforesaid, or the party making such acknowledgment be at the time of making the same beyond the seas, then within 20 years after such disability shall have ceased as aforesaid, or the party shall have returned from beyond seas, as the case may be, and the plaintiff or plaintiffs in any such action may by way of replication state such acknowledgment, and that such action was brought within the time aforesaid, in answer to a plea of this statute. The 6th section enacts that if in any action judgment be given for the plaintiff and the same be reversed by error, or a verdict pass for the plaintiff, and upon matter alleged in arrest of judgment the judgment be given against the plaintiff, that he take nothing by his plaint, writ, or bill, or if in any action the defendant shall be outlawed and shall after reverse the outlawry, in all these cases the party plaintiff, his executors, or administrators, as the case shall require, may commence a new action or suit from time to time within a year after such judgment reversed or such judgment given against the plaintiff, or outlawry reversed, and not after. The 7th section declares that no part of the United Kingdom of Great Britain and Ireland, nor the islands of Man, Guernsey, Jersey, Alderney, and Sark, nor any islands adjacent to any of them, being part of the dominions of His Majesty, shall he deemed to be beyond the seas within the meaning of that Act,